Hello and welcome to my YouTube channel. I'm Louise and the topic of today's episode is the difference between damage and damages. These two words are really often confused by legal English language learners. Perhaps you are one of them. And so we're going to break down the difference between them and make sure that you are using them correctly. If you're watching on YouTube, then please hit the subscribe button and do me a favour, share this with a friend or share it on social media. It helps me grow my channel. So let's dive into damage and damages. Although they look quite similar, they've got distinct legal meanings. Lawyers need to know these words, you need to use them, and you need to use them accurately. You can probably see already that one of them is an uncountable noun and one of them is a plural noun. So we've got damage, uncountable noun, and damages, plural noun. Let's look at the definitions. Okay, so the definition of damage, uncountable noun, this refers to harm or injury caused to a person or to property. It's the actual loss or destruction that occurs. It's the damage, the harm, the injury, the loss. An example sentence is the car accident caused significant damage to the vehicle. The vehicle got broken, got smashed up. Okay, so there was damage, there was harm, there was loss. So in this case, we use damage. Damages, on the other hand, the plural noun, this refers to the monetary compensation awarded by a court to a person who has suffered loss or injury. It's the financial remedy for the harm done. It's the compensation. It's the money paid. An example sentence is the court awarded the plaintiff $10,000 in damages for the loss caused by the breach of contract. Okay, remember plaintiff is used in the USA. Usually in England we use claimant. In any case, the damages here refers to the financial remedy. Let's now do a quiz. We're going to do a quiz, and you can see on the screen here, I've got lots of spaces for us to fill in. I've got lots of gaps for us to fill in together. We're going to have 15 questions, and you are going to decide what is the correct answer. Let's start with number 1. The earthquake caused extensive to the city. What do you think it is? The answer is damage. Okay, because it's harm, it's loss. Let's have a look at the next one. Number 2. The court awarded the claimant. The court awarded the claimant. What do we think it is? Well, the court can't award damage. They can't give a claimant loss. So it must be damages. The court awards a remedy. The court says, you, the defendant, must pay money to the claimant. Let's look at the next one. The company is liable for the caused by its defective product. So the defective product caused something, and the company is liable for that something. The company is responsible for causing something. So you can't really cause damages, because if you're causing damages, you're causing money to happen. But you can cause harm. You can make someone be harmed. So the answer is liable for the damage caused by its defective product. The product, which was faulty, did something bad and it caused a loss. Let's have a look at the next one. The claimant is seeking something For, my presentation doesn't show the F, the box is too big. The claimant is seeking something for emotional distress. So they're seeking, they're looking for, they're trying to get something, they're actively trying to get something for suffering a problem. So, of course, you're probably not going to look for damage. You're not going to look for harm or try to get harm, but you would try to get monetary compensation. The answer is damages. Let's look at the next one. The judge reduced the amount of something awarded at first instance. The judge reduced the amount of something awarded at first instance. Hopefully you're cottoning on. Hopefully you're getting the gist of the difference between these words. Of course, the answer is damages. The judge reduced the amount of damages, the money, okay, awarded at first instance. Next one, number 6. The benefit for the defendant pleading guilty is that this could mean less to his reputation. The benefit for the defendant pleading guilty is that this could mean less to his reputation. Of course, it's damage to the reputation. Next one, number 7. We're about halfway through. We can speed things up. So, number 7, if the party fails to mitigate the loss, they may not be able to recover any If the party fails to mitigate the loss, they may not be able to recover any damages. To recover damages. Next one. The claimant suffered significant to their property as a result of the defendant's negligence. The claimant suffered significant to the property as a result of the defendant's negligence. Of course, you suffer damage, you suffer a loss. Number 9. The court must assess whether the was foreseeable at the time of the incident. The court must assess whether the was foreseeable at the time of the incident, whether the damage was foreseeable. Of course, it's damage, whether the loss could have been foreseen. Also, we can tell that from the grammar, okay? Whether the damages would be, were foreseeable. Okay. Damages were awarded by the court, for example. Okay, let's have a look here at number 10. The insurance company is refusing to cover the caused by the storm. The insurance company is refusing to cover. This means to cover means to pay for the something caused by the storm. They're refusing to pay for the damage, okay? They don't want to pay for the damage caused by the storm. They don't want to pay money to compensate the harm, okay? Okay, next one, number 11. The expert report outlines the extent of the structural something to the building. The expert report outlines the extent of the structural to the building. Structural damage, okay, structural problems to the structure of the building. All right, we're coming to the end. We've got just a few more questions. Number 12. Something to the claimant's reputation is difficult to quantify, but could still be compensated. Something to the claimant's reputation is difficult to quantify, but could still be compensated. Damage, harm to the claimant's reputation is difficult to assess, to evaluate, but we can still give them damages, we can still give them compensation to remedy this loss. All right, number 13. The claimant seeks £50,000 in for the injuries sustained in the accident. The claimant seeks £50,000 in for the injuries sustained in the accident. £50,000 in damages. £50,000 in compensation, to seek a remedy, to seek damages in court, to look for, to try to get, to try to obtain. Okay, the penultimate question. Number 14. The solicitor advised that it's usually not possible to claim indirect. The solicitor advised that it's usually not possible to claim indirect, to claim damages, to claim indirect damages, to claim, to try to get damages. Okay. Finally, if a breach of contract occurs, the party suffering the loss can sue for. If a breach of contract occurs, the party suffering the loss can sue for, to sue for damages. To try to get money. You're suing someone, you're taking legal action. What for? Why? To get damages, to get compensation. All right. So that brings me to the end of this video. Thank you for listening today. Thank you for watching. I hope you enjoyed it and learned something new about damage and damages. I hope you can now use those accurately. Don't forget to sign up for podcast membership at studylegalenglish.com/pricing. And of course, check out my other videos. Finally, you can join my Study Legal English Facebook group, and you can find me on Instagram at Legal Englisher. And of course, why not try to make a sentence with damage and damages? Leave a comment in the section below. See you next time.